napa azundo meno meno manapa azundo meno bege skopa azundo skopa azundo meno azundo meno le chabe do gabaga igoro gabaga azundo meno azundo meno azundo meno anu majine gana jina kata kwa gare chino mabanu ku igoro chabe azundo jamu sama do kudu kudu weju kwa kejo ne magame armoro sama edi kebana to ne bala azundo meno azundo meno
You on my screen now and tell me what you think. You know what happened in the court last time about our leader Mazen Nnamdi Kanu. They are analyzing this video here, but I think the other our brother at the left hand, maybe I think he's missing something. Let me not say much, but please, if you're first time coming across this channel, don't forget to subscribe and turn on your notification. Also share the video for others to watch. Let's watch the video, and don't forget to tell me what you think about this video you want to watch now under the comment section. Thank you. I will be back.
Follow the last court episode, court session with what's his name? Nnamdi Kanu. Yes,
definitely.
Okay, hold on, please. Let me play this video.
An old man like this doesn't know the law. You don't know the law.
I've got the petition.
I have a petition against Big Tanya. I have a petition against her. Nonsense. Nonsense. Why is it when it comes to my case, they turn the law upside down? They turn the law upside down. Upside down.
What did you say?
Upside down.
What did you rules?
Listen. This is the laws of Nigeria. The prosecution and this court doesn't know the law. That is the fact.
Yes.
Poor knowledge of the law is killing Nigeria. Poor knowledge of the law, they don't know the law. This is a federal gazetted law of Nigeria that says here that the chief judge of Nigeria cannot tell Binta Nyeko what to do. It's here. It's your law. Just obey it. That is why I do what I do. I agitate for Biafra. I agitate for Biafra. My right to agitate. My right. They turned it from treasonable felony now to terrorism. Stop talking when I'm talking.
Sorry, sir.
Because these people, they are fools. They think they can mess. You can mess around with people who are not educated. I am an educated man. I can't show them the petition for the simple reason that if you show it,
What the judge said was that the case file was.
I don't recognize anything Binta Nyeko said today for the simple reason that she has no jurisdiction to try me. None whatsoever. I came out of courtesy and respect. She stands recused from my case and cannot try my case.
All right, there are things I decided to cut this about 4 minutes plus or whatever. Now, before I ask for your opinion on this whole thing, you know, we have talked about Nnamdi Kanu before, and honestly, initially I said I don't care whether even if he rots in jail, I don't care because I have issues with him. I support the Biafra agitation. There's no doubt about it. But what I feel that Nnamdi Kanu is the wrong messenger. We need the right messenger. Why? Because not that the guy is eloquent, he's charismatic, he has all the way. He's an intelligent man. But my problem with him is the way he agitates. He agitates with insult and division. He's been causing. See, before his incarceration, he was causing divisions, calling the North some names and whatever, calling the West some whatever. So a kind of some things that are very, very relevant with the agitation, with the cause. That was my problem. So I didn't care initially even if he rot in jail, because he was reckless with his utterance. But after watching this court session and reading what actually transpired in the court, because I was told that he literally took over from his lawyers and decided to defend himself. That was brave. In fact, after watching this clip, I became I rescind my decision to actually disregard whatever happens to it. Honestly, because I love courageous people. I have very, very strong passion for courageous people who are strong, especially in a time of challenge, in a time of intimidation. At this level, remember, barrister, because when someone, no matter when someone they do gara, so rash, so harsh, so outspoken and radical, vibrant, and against a system, the time you will know the true color of that person, whether the person is truly courageous or not, is when the person is arrested and incarcerated. When someone is under incarceration, give the person 1, 2, 3 weeks, worst case scenario, 1, 2 months under incarceration, the person will be humbled. Incarceration humbles people. If at this juncture, after several years, about 2 or 3 years, Nnamdi Kanu has not been humbled, he's still this fierce and courageous and bold to do this, to act in such a way. Honestly, he actually earned my respect. He has earned my respect, and he has actually earned my attention. And as such, this is the kind of person actually I would like us to talk about. Barrister, what is your opinion on everything that he displayed?
I will say straight away that I cannot agree with you on characterization of Kanu as a person you will support. What happened out there was nothing but a show of shame. We should never be allowed in a courtroom or a court hall anywhere in Nigeria and elsewhere. Now, one thing, as a lawyer, if my client should ever shout on me in the way he shouted on his lawyer in the court, there and then I will drop that case. You cannot, as an accused in the court, look at the way he shouted on his lawyer. Shut up! Don't talk when I'm talking. Who is he to shout on a lawyer like that? The lawyer that, at the risk of himself, is also trying to defend him. There are rules and procedures that guide the proceedings of a court. You are one person. You cannot come and change them. You cannot decide how the court should proceed against you because there are rules. You are shouting that the court does not know the law, that the ignorance of the law is the bane of Nigerians. So you are the only person who knows the law. Meanwhile, you are not the judge. Whether the judge knows the law or not, he or she is the judge who will end up pronouncing the sentence. And there is appellate procedure. If you are not satisfied, you go up. The court is not a place for agitation, for rabid agitation, insults, degradation of people. And that is what is wrong with Kanu, and that is why he has alienated a lot of people to him, from himself and from his cause. That kind of thing should not. Is that the kind of person that aspires to lead the Biafra nation? Can you imagine that kind of person being the president of Biafra? Is that not a dictator? Is that not somebody that will say his word is his word, nobody can challenge him? Is that the sort of person that should lead a movement like the agitation for Biafra? I will not support such a person. There's a place and a time for everything. You could not come into court, abuse everybody, even abuse your own lawyer, abuse the people you claim to be fighting, insult them, say anything that comes out of your word, your mouth. There has to be some measure of decorum, for God's sake.
All right. Barrister, thank you so much for your opinion. Yes, I love this disagreement, actually. But the truth, first, I understand your disagreement, where it's coming from, as a lawyer, a very senior one, who actually holds the judiciary in high, not our Nigerian judiciary, but the legal system in high esteem. There's no doubt about that. I appreciate that. But the truth is, I want you to understand that this man is a frustrated man, a man that the system, I don't know, you've been following, I've been following this court case of a thing. It's been a, excuse me, it's been a root of a whole lot of legal gymnastics. That's just the truth. This man has been, I think appeal court or so, there was a time appeal court, sometime last year or so, appeal court granted him bail. That he was ordered to, they had a ruling that he should be released. And the government refused to release him. And these court cases have been from one adjournment to the next adjournment, from one flimsy reason to the next. You and I, you know, even me myself, just use me as an example. How many times, sometimes ago, what did I do over some of my cases you have in court? What happened? I was very furious. And you seem to understand my situation. You calm down, you listen to me. Even when I was raging and yelling, a sort of, this is part of the frustration. This is me. I'm not even under incarceration. My own case in court, the cases you have for me in court, with me in court, they're all civil. And I am the one even taking people that took people. So you can imagine, yes, the court has been a frustration to the entire process. And remember how I reacted. That is even, I'm not even under incarceration. I wasn't even under incarceration. Yet I reacted in that manner. Talk less of someone who have been under incarceration, for God's sake. And listen, this issue of the lawyer holding over. Listen, respect is reciprocal, barrister. Respect, they say, is reciprocal. First, this man was under frustration. The lawyers have done all they could. The system is not listening to of course, they're not, just like you said, they follow the whole thing. And what the following the whole thing, the process as lawyers, what has it achieved for him as the client? It has achieved nothing. So the man, listen, but hold on, please. The man had to vent his frustration. He had to vent his frustration. And while venting his frustration, you as a lawyer too, you respect yourself. Respect is reciprocal. When you are trying to, two wrongs cannot make a right. You cannot be, two of us as friends, I cannot be angry and you be angry. Remember the day I vented, I did my own craziness over this issue of Nigerian legal system with you. What happened? You listened to me, you just kept quiet. Because you understood my frustration. That's exactly what Nnamdi Kanu just did there. And the lawyer, for him to tap, I was even happy. Let me be frank with you. I was happy he did that. And that if I were in his shoes, I would do the same thing. You tap him. Look, you respect. Look, they said respect. Even though you are my lawyer, I am paying you for God's sake.
Let's be very clear. There's no equivalent from what you are saying to what Kanu is doing. There was a time that Kanu was not in prison. And he had been like that. The kind of language he used is the language that he was using. Wait, let me
but you know, that was why I told you, hold on, sorry to cut you short, barrister, I'm sorry. That was why I told you initially. No, I told you and I have talked, this Kanu thing, you and I have the same opinion about him right from time. We've discussed him on this platform I think about a couple of occasions. We agree on this, and I mentioned it earlier, even before mentioning it at the beginning of this topic, that this man, the way he talks, he doesn't have control. He just talks anyhow. I talked about that. He's very unserious. Please go ahead. Sorry to cut you short.
Yes, I was saying that it is his antecedents. When he was free, he was saying the same thing. Yes. It was his mannerisms, his approach, his abuse. It was the same thing. So now that he's incarcerated, it's not as if the frustration of incarceration or the frustration of the trial brought about his outburst. He had always done that when he was not incarcerated, when he was free. Then, coming to court to begin to shout at everybody that nobody knows anything apart from you, particularly when what you are saying is not even correct in the law. What he's saying is not correct. when you say that the chief judge cannot give instructions, chief judge can give instructions.
Yes,
There are
even me, I think I know that one.
two
Yeah, you're
manners
right.
of it. There's administrative instruction and there are substantial instructions on the case. The chief judge can give administrative instruction in respect of a case, but not how a case should be proceeded with. And secondly, we are in the field. We practice, we go to court. We know how we approach a case. When your claims case is as bad as Kanu's case, when your claims case is as bad as Kanu's case, and you anticipate a conviction, sometimes we use another approach to frustrate the trial. So adjournment of a case is not always at the instance of the prosecution or the government. The defense itself can frustrate the proceeding because they anticipate that the trial will end in a conviction. So you use political means, you use a frustration of the proceedings. By writing petition against this judge, the case will be transferred and started de novo before another judge. By raising all manner of issues that do not touch on the substantive case, that way the case continues to be dragged on and on and on. Until you study the case and know why the case is being adjourned repeatedly, you should not jump to the conclusion that, oh, it is the government or the prosecution that is causing the unnecessary adjournment. Sometimes it is the defense that make that, and we have done it repeatedly as a strategy until sometimes political solution comes in. Sometimes external intervention comes in and saves the day, saves the person from being convicted one way or another. Of course, as we speak, there is agitation. Southeastern governors, Southeastern politicians, they have been trooping to Tinubu to release Nnamdi Kanu. That is political intervention. If the trial goes on without this, he will likely or probably be convicted and sentenced. Now, if the political intervention succeeds, he will walk away free without the burden of a conviction hanging on him. So there are strategies to go into a case.
Now,
we should not rush. We should not rush to conclusion that, oh, this case is taking forever, particularly criminal cases. It must be the government want to do this.
Yeah, but what about now? I wanted to ask you one question. I will come back to that question. But what about the situation where the situation where the court actually granted him bail and asked DSS to release him? And that is one. Secondly, before you answer that, let me add it with this other question. Are you also telling me that all these years that his defense counsel are not competent?
So you get it wrong. It's not that they are not competent, but you use a strategy to delay and frustrate the trial because you know your client will be convicted. So you wait for political intervention or some other kind of intervention that will truncate the trial, and it will not lead to that inevitable conviction. Now, when you talk about bail, remember the first case, even before Kanu came, the first case of somebody who was granted bail, a notorious, public figure, was the case of former National Security Advisor Dasuki, when he was granted bail repeatedly, but the government refused to release him. I think I gave an interview and I criticized the government because the basis of the refusal to release him was wrong. Then the government was saying that it is in the national interest, that national interest supersedes individual interest. They even quoted a decision of the court that said, yes, when it comes to national interest, it supersedes the interest of an individual. What they failed to, or the Attorney General then failed to advise Buhari was that it is not the president that determines what is in the national interest. It is still the court. The government will go and present the threat to the national security by the release of that person. The defense will also argue against it. The court will determine whether the facts presented before it warrant consideration of national interest and the non-release of that person. In the case that they have always cited, both parties, when the government presented his case that this man is a national security risk, the court agreed based on the facts and say in that case he should not be released on bail because national security trumps individual security. So to come and cite it when the court has granted somebody bail and say, oh, even the court said national security is paramount, is wrong, because in that case, the executive, in this case, the president, is the one sitting in his office and determining that somebody should not be released because of national interest. That is why I criticized that decision at that time. If at the point that the government comes to court and present all their evidence, and the defense also present, and the court determines that bail should be granted, then under the rule of law, the person must or ought to be released on bail as done by the court. If you are not satisfied, take it upstairs, go to Court of Appeal, and even end up in the Supreme Court. At the end of it, whatever the court
hold
says,
on. But let me ask you, since you want to go legal, let me ask you another one legal question. First, you know the issue of jurisdiction again matter. That's the foundation of the case matters a lot, and it borders jurisdiction. Remember how this guy was bundled, was kidnapped? That was illegal. I don't know how they did what happened in court over that argument, that proceeding. But the thing is, the basis for his arrest, the modus for his arrest was illegal. So what have you because the truth is, whatever, when you cannot build you can't build something on nothing. Because as it is by law, okay, let me ask you as a lawyer, I'm a very senior one at that. In law, can you actually build something on nothing?
No, but
when the foundation is faulty, can you actually build a case on it?
In terms of arrest, how an accused is brought to court has no relevance to the jurisdiction of the court.
Oh, really?
Let's be very clear on that.
Okay.
The fact that he was illegally arrested will not stop the court from hearing the case against him. So that really is not the same as saying you are building something on nothing.
Okay, so that
our laws, let me learn. Our laws here, both before when we were using the Criminal Procedural Code, and now that we use the Administration of Criminal Justice Act. Among it is, you will find a provision that says where an accused is brought before the court. So the manner you were bundled, arrested, or convinced to come to court does not affect the jurisdiction of the court. Once you are before the court and the charges are competent for that court, the court has jurisdiction to take it.
This Baba, I don't know. In fact, I don't just want to say much on this video. But if this man is in the shoe of Mazen Nnamdi Kanu, or maybe Mazen Nnamdi Kanu is his child, would he accept the kind of injustice Mazen Nnamdi Kanu is facing? I don't know which part of Nigeria he's coming from, maybe Yoruba, Hausa, or Igbo. But the way he's speaking there, he's speaking like as if he's one of all those people that has Igbos as their enemy. Let me not say much. Let me stop here, but tell me what you think under the comment section. Tell me what you think. That man, is he saying what he's supposed to be saying? Because exactly what that man is saying there is exactly the problem we are facing in Nigeria today. You will see the truth and turn it upside down. And that is exactly what make them push P2B away as a winner of the 2023 presidential election. In fact, when I think all these things, my heart boil. Let me stop here. But if you watch this video to this extent, don't forget to subscribe and share, and also turn on your notification button so that you will know when I bring interesting video like the video you just watched now. Thank you and God bless you.